right, good afternoon, ladies and gentlemen. We're ready to go with the second part of our Quant 2026, and we'll start discussing market in crypto asset regulation, tokenization, and implication for the industry with two leaders of this world, Ian Meli, his deputy head of the Securities Markets Supervision Unit, head of the Securities and Market Supervision Unit of the Malta Financial Service Authority, and James Farrugia, partner of Genado Advocates. Please join me on the stage and let's have a round of applause for the first two speakers of this afternoon. Welcome. Thank you so much for joining us today. Well, James, I'd like to start with you with a brief introduction, on the regulation of crypto asset and the transition to MiCA regulation, the Malta regulation.
Okay, super. So, thank you for having us here. Daniele, it's a pleasure to be here with you all. So, obviously, I'm going to bore you about Malta because we're both from Malta and we're going to obviously blow a bit our whistles, let's put it this way. So as far as Malta is concerned, so Malta has been in the crypto asset space for a very long time. It was the first regulator in the European Union which decided to regulate the intermediation of crypto assets. So brokers, exchanges, wealth managers, advisors, custodians of crypto assets became fully regulated under the Malta regime since 2018. Because in 2018, the Malta Financial Services Authority and the Maltese government enacted legislation which is equivalent to what we have today with MiCA. And that brought about a framework based on capital requirements, conduct of business requirements, risk disclosures, a fully fledged regime similar to the one of MiCA when all the other member states of the EU were implementing a framework purely based on AML registration. So then MiCA came along. In the meantime, a number of large players established themselves in Malta, like Crypto.com and OKX and Gate and many more, because they wanted to be front runners in embracing regulation in the sector, because they realized that the banking sector was never going to accept them unless they are regulated and subject to obviously AML. Then MiCA came along, and this gave us a bit of a competitive advantage. Why? Because at that stage, Malta had already under its belt 4 or 5 years of experience in the regulation of the sector and a very deep understanding of what to look out for when you are dealing with operators in the crypto sector. So MiCA came along and Malta became a jurisdiction of choice for quite a few crypto asset service providers which want to use now with MiCA their Maltese license to be able to access the single market of the European Union. Let's not forget that with MiCA, once you are authorized in a member state, you automatically have access to all the other 26 member states of the EU. So you're home and then other 26 member states and then investor population, which runs into hundreds of millions of individuals.
Well, Ian, talking regulation, there are different aspects. One is, MiCA versus MiFID when it comes to crypto assets. And another one is more connected with the latest trends on stable coins. And so the US regulation versus EU regulation. Where would you like to start?
Good afternoon, everyone. And thank you to Diamond for the invitation to this excellent conference, and well done for organizing it. As James said, Malta, we were front runners. So before MiCA came into force, we had our framework, the Virtual Financial Assets Framework, which was built on MiFID, so the Markets and Financial Instruments Directive, and that at the time regulated financial instruments. Eventually, we had MiCA from 1st January 2025, and we're through the grandfathering provisions until 1st July 2026. So what we used to call before as CASPs, Crypto Asset Service, as VASPs, Virtual Asset Service Providers, now have to transition and upgrade their licenses to CASPs, with the added benefit that they're able to passport across the EU. When it comes to the EU and the US, the approach is is significantly different in regulation. Looking at the EU, you have MiCA, and you cannot not mention MiFID as well, because MiCA gives a criteria of definitions, electronic money tokens, which are similar to stable coins, not exactly, but quite similar, as they are pegged to a single currency, asset reference tokens, and the other crypto assets. And on the other side, the MiFID, which regulates financial instruments. So the approach of the EU is that if the underlying is an apple and you tokenize that underlying, the token will retain the category of the underlying. So for instance, if you're tokenizing a fund unit, it will remain a financial instrument. When it comes to the US, the approach has been quite a reactive approach. In fact, until recently, the US was relying on case law on the Howey test, which was a court case decided in 1946. And last year, we've seen the enactment of the Genius Act. And at this point in time, it's still being implemented in terms of rules when it comes to the US. The Genius Act is not like MiCA. MiCA provides requirements, governance, capital, classification of different types of crypto assets. The Genius Act solely regulates stable coins. So it states that a stable coin has to be pegged to a currency or to short-term securities. And it requires a full one-to-one backing. It requires registration with the CFTC. So it has an element of patriotism in a sense in it, that it doesn't allow external parties to offer these services in the US easily, as opposed to MiCA, where you can offer the services in the EU.
That's the America First approach.
Yeah, and then there's the Clarity Act, which is still being debated, but and it has passed the House of Representatives, but hasn't passed through the Senate. But at this point in time, naturally, this will not be a priority of the Senate. So the scope of the Clarity Act is to provide, or the Crypto Act, to provide clarity on the definition of a security, how a crypto asset is defined, whether it's a security or a commodity, because at US level, there is lack of clarity even how a crypto asset is defined. And essentially, it also lays down the principles on the responsibilities of the respective regulator, the SEC, which will supervise securities, and the CFTC, which will eventually supervise commodities. It also provides a platform, once it is enacted, on how you can convert from a security to a commodity. And essentially, it takes into consideration the DeFi element as opposed to MiCA. MiCA regulates the centralized financial exchanges as opposed to DeFi.
James, what's more relevant to understand when it comes to classification of crypto assets? And Ian already mentioned, difference with MiCA and MiFID.
I mean, the classification of crypto assets is becoming, very challenging, and I'll tell you why. So you have MiCA, which creates a concept of crypto asset, which is nothing more than, a token which is operating on a distributed ledger technology, essentially. But it then hard defines 3 types of crypto assets. So electronic money tokens, which are the stable coins like USDC. USDT is a tricky one because it's obviously not registered for distribution in Europe, unfortunately, or not yet at least. Then you have the asset reference tokens, which are the asset-backed kind of tokens. Again, very difficult to define because they come very close to a financial instrument as a definition. Then you have obviously the other crypto assets, so your typical native tokens or your utility tokens. But then, and that's the MiCA world. But then you have a different world, which is traditional financial services. So we've all heard the term tokenized stocks. Right now you can go through a platform and you can buy a token which is giving you exactly the same performance as shares of Apple. You still get a manufacturer dividend, but at the end, which obviously you would get from really owning shares in Apple. So, but in reality, it's a token. So when you look under the hood and you start studying the characteristics of the product, pretty much to determine whether an entity can sell it or not, based on its license, and what are the rules of engagement when you're selling it. So when you look at tokenized stocks, you will more often than not realize that they are nothing more than funded total return swaps. So the design of them, so under the hood, the engine, is pretty much a funded total return swap, which means that when you're selling a tokenized stock, you're really selling a funded total return swap, which means MiFID applies, which means it's a complex product, which triggers certain appropriateness assessments, and so on and so forth. Then you look at fund units, and Ian mentioned this. So if you are tokenizing a fund unit, right, yes, you're getting a token, but ultimately it is a fund unit, which means that your rights and obligations are those of a fund unit holder. And the way that you sell it is, again, as if you're selling a normal fund unit. Then we have, obviously, the very famous old term security tokens, right? So typically a bond or a share, which is actually in a tokenized form. So rather than holding an actual bond, you're having a token, but you have the same rights and obligations as if you were a bondholder. Or maybe, security tokens, which are shares, which give you an ownership right in the entity which is issuing them. So the issue with tokens is boxing them, right? Because they are, the same token can give you the same economic exposure. So you might have 4 or 5 tokens giving you the same economic exposure to a reference asset. But when you look under the hood, they're different by design. So then you need to be careful that you classify them properly in the right box. Because if you misclassify them, you might breaching the rules in the way you're selling them. You might breaching the law because you might not have the right license to sell them. Because you might have a MiCA license when in fact you need a MiFID license. So declassification of token is the single biggest headache I'm facing at the moment. When a client come along to tell us, listen, I want to sell this. Is it possible? Do I have the right license? What process do I need to follow when I'm selling it? And you need to really look under the hood very carefully.
Well, sounds challenging and also dangerous from some point of view, so you need a deep knowledge of this. At the same time, you mentioned at the beginning the localization in the jurisdiction and the multi-jurisdiction of some of the biggest players in the space. What can you add in terms of the ecosystem for crypto as a service provider in Malta now?
I think we're quite lucky in the sense that we are, as a country, and all the practitioners, so all the lawyers and the accounting firms and the regulator, they've been dealing with the sector now for the past 8 years. So this gave us the opportunity to understand the nuances around custody, the nuances around operating at a crypto trading platform, a crypto asset trading platforms. In reality, to be fair, I come from the securities world. So when you really look at a cryptocurrency exchange and you compare it to a traditional exchange, the engine is quite similar, really. So you have a central limit order book, an order matching engine, right? Maybe a crypto exchange, a centralized one, is combining a CSD and the exchange in one legal entity, right? Whilst in the traditional sense, maybe sometimes they are separate and sometimes not. So in reality, the design lends itself a lot from the traditional financial services. But then over the years, you learn, as I said, the nuances are resulting from the sector. So as legal professionals, as accountants, as regulators, we've been dirtying our hands with the sector for many, many years. And during this process, we've learned a lot. And this puts us in a very good situation in the sense when clients come along and approach us to set up a business in Malta, for instance, a crypto business in Malta, and we tell them, okay, now you need to take into consideration these elements, we meet the regulator, and so on and so forth. And more often than not, they would be shopping around in different jurisdictions. They immediately realize that we're speaking exactly the same language. When they meet the regulator, they meet someone who's understanding what they're saying, right? Who knows the pains of their business, who knows the areas where they need to focus on, which is the areas where the risks lie. And at the end of the day, they see an ecosystem which is welcoming to the sector, which I wouldn't say it's unique in the European Union, but there is only a handful of jurisdictions which is taking a positive approach towards this sector in the EU.
Well, Ian, James said, to set up a business, to play the game into this space, well, you need authorization. How about the process of authorization? What is the supervision point of view?
No, from an authorization perspective, I think we have to separate the full authorization process from the notification process, what we call the Article 60 notification process of MiCA. So when there's a full authorization process, obviously the MFSA has its own standards and its own processes, but the first step is always to set up an intent meeting with the applicant. So we ask the applicant before actually submitting the application. So we ask the applicant to give us a presentation on the business model, the setup, the control functions, how they're complying with capital requirements, and profitability projections, etc. And we give an indication whether, listen, this is sufficient to proceed with the pre-authorization and the submission of application, or whether there are key red flags which needs to be addressed. So in that manner, we prevent toing and throwing with the applicants. Eventually, we're quite an agile regulator, so if we have applicants who are willing to meet us, as a maximum, we try to meet them within the week. And
within the week?
Yeah, within a week. A maximum, unless obviously something crops up or we're abroad or something. And even high-ranking officials of the MFSA are available to meet applicants upon request. Then once we go through the intent and the documentation are submitted, we start the review process. We go through the due diligence when it comes to the PQ'd individuals, and we review the corporate questionnaires and the application forms. At that point, there's a decision whether to authorize or not, but it's not a clear-cut yes or no, because to be flexible, we adopt the approach of issuing what we call a minded authorization. So we call it a pre-authorization letter. So we issue a letter, listen, we're in the final stages, we're amenable to consider the authorization of this CUSP, with firm fund, because it's the same process, and we list what is pending. So we have, then once we list either pre-commencement conditions or post-commencement conditions, depending on the severity of the case. For instance, we don't expect, I mentioned the funds and the MiFID business as well, because I come from securities. For instance, if you're setting a startup, we don't expect that you have a fully fledged compliance function. So we understand that outsourcing could be beneficial in that aspect. So we include conditions, for instance, that upon either reaching certain size of thresholds or assets under management, then those individuals would need to be appointed on a full-time basis.
Well, James, what's your experience into this?
I mean, the authorization process, first of all, is set out in a public document which is called the MFSA's Authorization Charter. So what Ian just told you is there in the public domain. And the process is a process. It is very document intensive. So, I mean, you need to file a fair amount of documents in support of an application. The intent stage is a very good filter. Because if the applicant is not within the risk appetite of the MFSA, they'll just tell you, you're not really for us, we're sorry, right? And it may well happen, because maybe, people come along with a lot of enthusiasm, but to run this business, you need quite a bit of money, right? Because as we know, the cost of client acquisition in the online business is what it is. So ultimately, once we go over the hurdle of the intent stage, then it is a matter of going through a process like every other process. So you need to file application forms, due diligence information, and so on and so forth. The MFSA will focuses a lot on due diligence, proper substance, DORA compliance, AML CFT compliance, disclosure requirements, and the proposed disclosures on the website. So there are a number of key areas that are assessed in detail at the authorization stage, right? But again, you go through the process, you send the documents, they come back with comments, you reply, they come back with a second round of comments. Generally, after the second round, you get what Ian mentioned as the minded authorization letter, and then from there, it's really...
Well, Ian, there's just one point left that I would like to discuss with you, because James was introducing tokenization of crypto assets. What's the MFSA position on tokenization on funds unit?
No, our position has been quite clear on tokenization of fund units. In fact, we've published the first paper in July 2025, which tackled the transfer agency element of tokenizing a fund unit. So the MFSA looks positively at tokenizing fund units. At the time, we were considering initially the transfer agency element to communicate the approach that, as regulator, we're taking, in the sense that we're amenable to consider funds to tokenize their units. We didn't make, it's not reinventing the wheel, because fund units, to a certain extent, are already dematerialized, but the difference is that instead of having a digital certificate of a fund unit, you would have a token in a wallet. Obviously, we wanted to assure that the wallets are safeguarded and they're in terms of AML, they're robust enough. So we introduced also certain filters and safeguards and disclosures in the offering documentation to ensure that ultimately the client is protected. Now, we're at the second stage, and we're at the very final stages of publishing another position paper. The position paper, through the position paper, will be communicating a potential use case, which is, this morning it was already mentioned, collateralization of fund units. So we've started with the transfer agency. So the fund unit is tokenized. Then how can that tokenized fund unit be used? And in the paper that we're currently finalizing, we're proposing that the fund unit can be pledged or collateralized either with a broker or with a credit institution. Potentially, we've also taken into consideration the DeFi element. And obviously, the lender would consider potentially the margin, and through the DLT network, that collateralization element can take place. Now, I mentioned the DeFi, and we know that there are certain risks related to DeFi lending. So we wanted to keep our standards high, and the proposal is that this model will only work if there's a whitelisted liquidator. So that if there's a margin call, the liquidator will step in and he'll take over the control of and safeguard the interests of the lender. And we'll be publishing also criteria on what the whitelisted liquidator is expected to have. Now, tokenization has been quite a buzzword, to be honest, and it's mentioned in every conference. But what I always ask, is there a market for tokenization? Have we seen these tokens being traded? And the answer that I get is that it's still early days. I mean,
yeah.
When we started with credit cards, we started with the card, you could only withdraw money, you couldn't pay with the card. So it's the same technological process. So I think we would need to wait 4 to 5 years until we see the actual market makers in the tokenization element. So we're taking it step by step. We're starting with the tokenization of fund units and the collateralization method. Eventually, we'll move on with how things develop.
In fact, I mean, as Ian rightly pointed out, when one looks, I mean, it's quite sexy to say, you know what, I'm tokenizing my fund. But in reality, when again you look under the hood, you start realizing that there are AML issues that you need to worry about, transferability issues that you need to worry about. If you are lending them, or rather giving them as collateral in a DeFi lending context, right? It's a big question whether the lender can enforce that security, because let's not forget that you cannot transfer fund units unless the fund approves the incoming shareholder, right? Obviously, I'm assuming that the fund is not listed and traded. So again, you cannot just give your fund units as security, then someone wants to enforce it. He goes to the fund and tells the fund, hi, I'm the new shareholder now because I had this piece of paper called a pledge and I'm enforcing it. And the fund tells you, you know what? I don't really like the color of your eyes. I'm not really going to accept you as a shareholder. So where does that leave the lender? So there are a lot of hurdles that we need to overcome in order for the tokenization of fund units becomes a real option, right? Because as I said, it complicates the life of transfer agents, for instance, and fund administrators. Why? Because today, if you want to buy a fund, you go to the bank, or your private bank, or your broker, you give them the money, they subscribe in their own name. The fund administrator is very happy because they're getting a subscription from BNP or from one of these big sort of investment banks. And the due diligence is very simple. And they just say it's BNP, so it's fine. And that's fine. The moment you introduce tokenization, you are empowering the end user to actually subscribe in his own name and hold his own token, his own fund tokens in his own self-hosted wallet. Which means that now the fund suddenly has to undertake due diligence on James Farrugia, not on the bank, which means source of wealth, source of funds, identification, verification of identity. So as a fund administrator, it's much more complicated to onboard James Farrugia as a client rather than BNP.
Ian, what do you want to add?
What I wanted to add is James mentioned the transfer agency. In the ideal, and the fund administration, in the ideal world, the registrant to make things efficient would be the DLT itself. Nothing against the fund administrators, but at this point in time, the technology that we have to date doesn't allow that. So the single source of truth when it comes to the register of the fund still lies within the fund administrator. And another challenge is the discrepancy in valuation. So if you have a lender, would the lender accept a valuation of a fund units which is carried out annually? Would the lender be happy to ensure that the value of the collateral remains adequate when you have an annual valuation?
Yeah, there are quite a few challenges that we'll still need to overcome, but I mean, we need to look at it with positivity and we'll get there, I mean, one day, but I am not sure we're there yet. If you speak to the fund administrators, I don't know if there are any of you in this room, but they will tell you, you know what, the fund units are tokenized, but I'm still keeping the register in my fund accounting system, right?
Well,
so
that was truly interesting. So thank you so much for sharing your vision and experience. Thank you to Ian Meli, who's Head of Securities and Market Supervision at the Malta Financial Services Authority, and James Farrugia, Partner Ganado Advocate. Thank you. A round of applause for them.